Unit 3, question 2. How and why did the 14th Amendment enlarge and extend due process rights? The Constitution does not define due process as law. How would you explain the meaning of due process of law? Finally, in what ways are procedural and substantive due process alike? How are they different? You may begin when ready.
Originally provided for in the Constitution's 5th and later 14th Amendments, due process is the single most important protection against the corruption a powerful government creates. Government power is necessary in order to protect the common good and order, as seen with the failure of the Articles of Confederation.
However, individual rights cannot be cast aside for this purpose. A balance must be kept between powerful government and protection of rights. To check government, rights defined as fundamental in Palco v. Connecticut as essential to a scheme of ordered liberty must be undeniably protected, namely speech, property, life, and liberty. Due process is a set of procedural roadblocks ensuring that the deprivation of any right is absolutely fair and justified.
Due process is not explicitly defined in the Constitution. However, some procedural due process guarantees appear in the body of the Constitution and the Bill of Rights. Article 1, Section 9 promises the privilege of the writ of habeas corpus and prohibits bills of attainder, and Article 3 establishes the trial of all crimes by jury.
In the Bill of Rights, the 4th, 5th, and 6th Amendments provide procedures for search and seizure, protect against self-incrimination and double jeopardy, and guarantee a speedy and public trial by jury with the assistance of counsel. These and other protections of due process made their way into the Constitution because of the founders' English roots and the common law tradition.
Due process was implied in the Magna Carta when King John promised to obey the law of the land, and was specifically stated in a 1354 Act, which said no man would be put out of his land, imprisoned, or put to death without due process of law. State constitutions provided for similar procedures.
These state guarantees of due process were not infallible, however, and because of the 1833 Barron v. Baltimore decision that the Bill of Rights did not apply to the states, the 14th Amendment was later needed to stop states from abusing due process rights based on race, gender, and other classifications.
This amendment extended due process by stating that no state shall deprive any person of life, liberty, or property without due process of law. The states were responsible for keeping African Americans in a slavery-like condition with black coats, stripping former slaves of any rights they had gained with their freedom. The Due Process Clause addressed this problem because it directly applied to the states, and through selective incorporation prohibited states from violating fundamental rights.
Along with the traditional procedural due process, the Supreme Court has found that there is a substantive component to due process, in which courts review laws and determine whether they violate any rights believed to be so fundamental they cannot be infringed upon. Procedural and substantive due process are alike in that they both limit the government and serve to preserve individual rights.
They are both derived from the same clauses in the 5th and 14th Amendments. However, procedural due process is clearly spelled out in the Constitution, whereas substantive due process arises out of judicial interpretations of the due process clauses. The rights of the accused enumerated in Amendments 4, 5, 6, and 8 include procedural due process because they lay out what the government must or must not do when it intends to deprive any person of life, liberty, or property, or otherwise punish or sanction them.
Substantive due process is implied by the words liberty and property in the due process clauses, and also by the 9th Amendment's statement of unenumerated rights. Whereas procedural due process lays out procedures that must be followed in order to take away rights, substantive due process prohibits certain laws entirely if they infringe on fundamental rights too greatly, such as the Supreme Court decision striking down sodomy laws in Lawrence versus Texas. Some of these fundamental rights are clearly stated in the Constitution. For example, the First Amendment rights to religious freedom, free speech, and freedom of assembly.
However, substantive due process also protects rights that are fundamental but not clearly expressed in the Constitution. The greatest example of such a right would be privacy, which the Supreme Court found to be fundamental in Griswold v. Connecticut in 1965. In Griswold, the court found that banning the use of birth control by married couples interfered with their liberty, establishing the right to privacy. This created precedent that later established the right to an abortion in Roe v. Wade.
Due process is one of the most important rights of individuals in a free society because it prevents the law from being used against an innocent person. As political writer Benjamin Constant said, "Is the natural enemy and unyielding foe of tyranny, whether popular or otherwise." Thank you.
For one.
13.
Why not have a fixed concept in this definition of due process?
Well, it's been stated that due process is both an ancient and evolving concept, and having it fixed would get rid of that evolving concept, such as you can look at Jones v. U.S., where the court ruled that you can't put a GPS tracker on a car without a warrant. If we had a fixed idea of due process, then we wouldn't be able to add things with, say, the growth of technology.
Because the Supreme Court has had to define what due process is, that has made it flexible. And that's the reason we have substantive due process that created the right to privacy. That is why we have due process protections in administrative procedures and not just civil and criminal procedures. So the fact that due process is not well defined has actually been better for individual rights.
I agree that it needs to be flexible. For example, due process needs to be provided when you take away Social Security disability benefits. In the case of Matthews v. Eldridge, they established that there is a form of due process required, but that doesn't necessarily include an evidentiary hearing. So due process needs to be flexible depending on the situation.
The 14th Amendment's Equal Protection Clause, does it protect sexual preference as a civil right?
Recently, it has come to do that. In the Supreme Court case of Romer versus Evans, the court struck down a Colorado law that made it illegal, a ballot initiative actually, that made it illegal for cities to impose ordinances protecting gays against discrimination. And that was also an issue in Lawrence versus Texas.
Did you say sexual orientation?
Yeah, could you repeat the question?
Yeah, sir. The sexual preference, I said sexual preference, but sexual orientation. I'd be interested to see what you make the distinction there.
Well, I don't have an answer, but when you said preference, like, I thought you meant like preferring a woman to a job over a man or something like that.
That's what I
Rephrase your question.
I don't
it's
have an
fine.
answer anyway, so.
No, it's
Where's
fine.
that?
Wait, so you were talking about like employment discrimination, not gay rights?
I was talking about gay rights.
Oh, okay.
14th Amendment protect gay rights?
I just answered the first one. I just answered that.
Okay, answer it again.
Okay. Well, it does. In Romer versus Evans in 1996, the Supreme Court struck down a Colorado ballot initiative that prohibited cities from passing ordinances protecting gays and lesbians against discrimination. And that was also an issue in Lawrence versus Texas. Equal protection protects homosexuals against discrimination.
I don't have anything to add.
As of right now, not through the Equal Protection Clause, but in Loving v. Virginia, marriage is protected as a fundamental right. That hasn't been extended to marriage outside of a man with a woman. But with the states acting as laboratories of democracy, as New York has recently made legal gay marriage, I foresee it becoming legal countrywide soon.
Can you give me an example of where something acts both as a procedural due process as well as a substantive due process?
Yes, double jeopardy is both procedural and substantive. It prevents the procedure of trying somebody more than once for a crime, but it's also substantive because if the government could try people over and over again for the same crime, they could convict anyone for whatever they wanted and we wouldn't really be a free country.
The right to counsel also can be construed that way because, of course, it's procedural, but substantive in that not only do you have the right to a lawyer, but you have to have enough time to prepare an adequate defense with that lawyer. For example, in the Scottsboro case, Powell v. Alabama, it was that they had a lawyer, but they didn't have enough time.
You could make the argument that any right, such as trial by jury, that's essential to an ordered scheme of liberty, as defined in Powell v. Connecticut, as both substantive and procedural, because there are procedures, say, for selecting a jury that has to be proportional to your relative population, but it's also essential to your free lifestyle in this country.
The Fourth Amendment right against unreasonable searches and seizures would be both procedural and substantive. It's procedural in that the government must follow procedures in getting a warrant and having reasonable circumstances to search or seize someone's property, but it's also substantive because it protects people's privacy and it protects their homes and bodies.
Has the idea of substantive due process been abused by the courts? Have they gone too far in their role in seeing this idea of substantive due process?
That has been considered at times. for a while in the 1930s, the Supreme Court was using an idea of economic substantive due process to strike down a lot of President Roosevelt's New Deal legislation. Eventually, some new justices came to the court and they saw that interpretation as flawed. They stopped doing that. Later, Sandra Day O'Connor concurred in Lawrence versus Texas, but she decided that that law should be struck down on the Equal Protection Clause because it was specifically targeted at homosexuals. They didn't need to go the extra step in using substantive due process. So she thought substantive due process had gone too far.
Substantive due process can be misused. I think Antonin Scalia has spoken out against it, like the idea that there's no right to an abortion in the Constitution, so you have to make it up. And essentially that's what it is a lot of the times. I think even though it's defined in Palka versus Connecticut what fundamental rights are, it's still a rather vague definition. And it has been misused. For example, Dred Scott, they didn't use the term substantive, but it essentially was substantive due process, the idea that people have this right to own slaves and it can't be taken away by the Missouri Compromise or any other.
You can also look at Citizens United versus FEC as the court's going too far in a substantive case, saying that they have the right to free speech and that the fact that speech is considered money as made it a lot easier for money to filter into our political system and corrupt it.
What do you think of the GPS tracking case? Did that go too far? Was it Jones versus?
Well, it's easier to say that something goes too far when it abuses the rights of people. So in that sense, it's easy to look at the Jones case and say that it doesn't go too far because it is actually in protection of people, and it in fact hinders the law enforcement more than it does the people.
One commentator said that the Jones decision didn't go far enough because it was a combination of three factors that led the Supreme Court to make their decision. The fact that the government had placed a GPS tracking device on someone's car did not constitute violating their rights. It was the fact that that device was left on the car for a long period of time and used to track their movement and used to find the location where they were hiding their drugs. There was three factors, not just one.
Is this idea of due process, is it more of a classical Republican idea or a natural rights philosophy?
Due process would undoubtedly be a natural rights idea because of the way it serves to protect liberty and property, ideas that are very tied to natural rights, and substantive due process especially, because that idea is that there are some rights, there's some things people do that are so fundamental that they just can't be taken away. And the government's desire to take them away can't even be justified by the idea of the common good in classical republicanism.
Due process can also be considered classically Republican because it keeps order in the society, and the more cohesive and order the society is, the better it's going to function, and the more, with that guarantee of rights, the more functional your society is going to be. And it also plays into civic participation, like your due process right to a trial by jury. That's participating in your government, which is classically Republican.
I would say that due process is almost like a balance between both natural rights philosophy and classical republicanism because it provides for the procedures of maintaining this order that is for the common good, but it does that by protecting the rights of the individual, if that makes sense.
Does the select sovereignty of states that has existed in that relationship throughout American history, does the incorporation go too far in having states protect their people in certain things by striking down state laws such as Texas versus Johnson versus Texas and others, Loving versus Virginia, in which they're trying to protect the police powers of certain areas?
Well, selective incorporation wasn't originally delineated in the Constitution because it wasn't seen as necessary because these state constitutions were supposed to protect people's rights. But you can look at the black codes and the poll taxes and things like that that show that state constitutions clearly weren't protecting everybody's rights, and so that's where the federal government needs to step in.
Can I give an answer?
Go ahead, answer.
Also, the reason incorporation is so important is because states are responsible for most of the criminal prosecutions in this country. If incorporation hadn't happened, 95% of crimes could be punished without really any due process.
Good. Go ahead, feedback.
I think you guys did a good job of drawing distinction between procedural due process and substantive due process. We hit you from a bunch of different angles in terms of how to consider that. I think you guys did a good job. That was really good, I thought.
Yeah.
The cross-ex. That's because substantive and procedural is tough for a lot of people. I mean, even for me. I mean, I teach it, so I mean, it's a tough concept, and you guys really obviously understand it very well. I was impressed. I learned some stuff too, so good job.
Okay, on the question of it, too far in substantive due process, and you're talking about Anson Scalia, and I just think one thing you guys were missing was that idea of the Ninth Amendment in terms of where that also could apply. And you guys talked about Griswold a little bit in those penumbras, but bring that in there of where it could possibly lie as an argument. Shane, when you talked about the New Deal legislation and the ideas, it's, what is it,
Lochner.
Lochner is the case that leads up to,
The switch in time and save.
yes, it's the Parish versus West Coast Hotels. So it's the Lochner case that kind of leads the Supreme Court until that case, and then they change out of it.
So Lochner was the economic substantive due process precedent. West Coast Hotels was the one that overturned that.
Correct.
Okay.
Well, there were a lot, but Lochner's like the most well-known, I'd
Yeah.
say.
Right, there were a lot of them.
One of the cases I sent you guys today is that I heard from the judges that they're really interested in is the Maples versus Thomas case. And Mr. Carlin kind of sent you a little quick review on it.
We spent like 10 minutes talking about that.
Good.
Carl.
Just make sure, that's another one of that idea of both procedural and substantive due process there, because the state did everything procedurally correct, but because of the flaws that took place, there's where the substance.
The person's own attorneys violated his due process
Correct.
rights.
Right, and that's that substance due process.
So an argument could have been made against him that the government never violated his due process, and due process is only supposed to apply to the government. But,
Correct.
and you could also make an argument that this only was even an issue because this was a death penalty case.
Correct, in that light.
Yeah.
And the case that creates substantive due process where it's first specifically mentioned is slaughterhouse. So that's the
wording, not the concept.
the wording of substantive, because New Orleans has the power to rezone areas, but they made it into a monopoly of one area. Mr. Oaks and I have learned a little bit more about it, and that's where the substance of the way they created the zoning laws became a where those who were in dissent saw the violation of the due process. The Supreme Court didn't see it that way in the equal
majority.
the Privileges and Immunities Clause. Okay? But man, you guys did an awesome job. The only other thing is just, as you guys get more used to the paper, just not here, but here with them, the binders. So that's
Wait,
just
hold
one
them?
thing. Yeah, hold them. Just kind of, I mean, you don't have to be like here with them, but just kind of so they're at an angle, or if you can have one hand underneath so you can kind of find your spot. That's just little, that's just
I
practice.
like to just hold my paper out.
That's fine.
It's easier to read, it's easier to look at.
That's fine. Go, switch. You guys are good.
Fantastic.
Thank you.
Whew. I try to come at every unit with a question for you guys. That was good.
Guys, that was really
You
good.
killed it.
That was really good.
That's the one.
That was super fast.
You,
I got 11 out of 10.
like,